My name's William Malcolm, a lawyer with Pinsent Masons, the law firm behind Outlaw.com. Last time we looked at some of the legal issues surrounding the transfer of data to suppliers. Today we're going to turn to more of the practical issues, looking at some of the issues you might consider day to day in terms of identifying, managing and mitigating risk. The process of identifying risk should start at the outset of the project. One of the first areas you'll look to consider is the nature of the transfer itself. Will data be transferred from you to the supplier by courier? Will it be transferred by post, or will there be some form of electronic data exchange? By looking at the nature of the transfer itself, you're looking at one of the principal vulnerabilities in the chain at the start, and it's important to ensure that you've properly assessed the risks in relation to this. The second issue to consider is what rights of audit do you need? Now, of course, the right place to put rights of audit is in the contract, but you need to consider practically what rights of audit you need, what you want to check on a day-to-day basis, so that you can get the balance in the contract right. And you also need to ensure that the audit plan is drafted at the start of the process, so you know when you're going to check compliance with the policies and standards that you have set. Next, we need to consider the reliability of the third-party staff. Now, you will have your own internal policies and procedures in relation to the management and selection of your staff. You need to consider which of those is appropriate to flow through to the supplier, what existing standards that the supplier may have which are appropriate to you, and ask yourself practical questions. Do you want only certain members of the supplier staff working on your account or getting access to your data? Are you happy with the standards of vetting that the supplier has in place? And are you happy with the standards of employee selection and training that the supplier has in place? Then you need to flow through the responses to these questions into the plan and into the contract. Next issue you need to consider is the reliability of the physical and technical infrastructure of the service provider. Does that infrastructure afford you the appropriate standard of security that you require and that you've identified in terms of your previously conducted risk assessment? Does that technical infrastructure give your business the benefits that it needs in terms of scalability and the ability to change over time? Next, you'll want to look at how long the third party should keep the data. Is the third party going to act as a data warehouse for the data, or does the third party only need access to it for a specific purpose, such as printing a statement or issuing a mailing to a customer? Lastly, you want to look at whether or not the third party is entitled to use subcontractors. This is an absolutely key issue, and if the supplier does want to use subcontractors, whether here or overseas, you want to ensure that the processes for the selection and management of those subcontractors and for approval of the technical infrastructure that the subcontractor has in place are right. So you've identified the risks. How do you mitigate and manage them? By drawing upon the standards that are set out in ISO 27002 and other applicable international standards. These standards set out important ways of managing and mitigating risks in terms of processes that you can require the supplier to undertake in order to achieve compliance. But the key issue is that you actually have to select the processes that are right to mitigate and manage the particular risks that you've identified. Once you've done that, then you're most of the way there. But that's not the whole story. That plan for mitigating and managing risk has to dovetail properly with the contract, and you need to ensure that the contract reflects the plan and that the two sit neatly together. Once you've got through that stage, then you're ready to go. So what is the range of practice out there? Some organisations sign up to contracts simply stating that the supplier will take appropriate organisational and technological safeguards. Other organisations sign up to contracts with incomplete or incomprehensible security plans, promising to work out the detail later. And even the very best organisations tend to enter into contracts with detailed security plans, but then put those contracts in a drawer. They don't live and breathe the contracts, looking at audit and looking at ensuring organisations are complying on an ongoing basis. All of that may seem a bit theoretical, so let's look at a practical example. Let's take Staffcare, a company that provides services which allow employees to access details of pay and benefits. Staffcare performs these services for KPMG and EMI, among others. So by looking at this example, you're probably identifying some of the information security issues that may arise. What would happen if salary details of all staff were lost in transit between your organisation and Staffcare? What would happen if one employee erroneously accessed the details of another employee through being issued with the wrong user ID and password? Additionally, what would happen if Staffcare simply could not evidence through a proper audit chain how details of a member of staff had been updated, or how selections in relation to certain services or salary sacrifices had been made? Some questions to consider if you were transferring your personal staff information to an organisation like Staffcare. How would the transfer or upload of the information to the Staffcare site work? How would authentication for staff work? And finally, how would you ensure that the organisation had the right audit trail in place to show who accessed information on your staff and what benefit decisions were made by staff? So assuming you've done all of that, mistakes might still happen. So how do you manage an information security breach should the worst happen? Well, one of the first things you should do is think about, in case of emergency, break glass plan. The experience of Pinsent Mason's lawyers has shown that a lot of time is lost in the first 24 hours of a security breach because basic decisions can't be made because people don't know the right communication channels, who to contact, what are their mobile numbers, what's the decision process, who decides whether or not to switch off the IT systems, etc., etc. So although it may not seem particularly complex, having a one-page what to do in an emergency plan, who do I speak to and who do I contact, is the first thing you need to do. So you've got through that initial panic. What do you do next? Well, next you need to investigate and see what remedial action needs to be taken in order to move forward in terms of managing the breach. You also need to consider what to tell customers and what to tell regulators. The ICO guidance suggests you should tell customers if there is particularly good reason to tell them, such as they may be at increased risk of identity theft, or they may have to be on the lookout for unauthorised access to their personal information or accounts. Do you tell the regulator? Well, this is a complex issue and many issues need to be taken into account. Regulators will appreciate organisations that are open and honest in terms of their approach, but one has to consider whether the breach is of sufficient magnitude and what information the regulator will want to receive about the breach. This is something you need to work through carefully with the team and take legal guidance on as required. The key theme running through all of this is preparation. It's fair to say that the law hasn't changed in recent years, but the operating climate certainly has. Increased customer and consumer expectations, increased expectations from regulators, and these high-profile string of security breaches focusing media attention on information security issues. Couple that with the increased prevalence in the boardroom of reports of information security breaches and the need to take information security seriously, and you have a recipe pointing towards the need to sharpen up focus in this area. Understanding all of these issues will help drive the right security response. You've got to make sure that the contract you put in place doesn't live in a drawer, that the programs for ongoing audit, continuous improvement and assurance are there. By changing your behaviour in these key areas, you can help ensure that legal risk is properly managed and mitigated, and that the security response of your organisation helps protect customer experience and enhance customer value.